numerous health challenges, and that will be part of the position taken when we come back in a number of weeks with respect to what sentence would be appropriate in the circumstances. And right now it's a matter of considering the outcome and considering whether the rulings will dictate an appeal.
What does today's convictions on 4 of the 5 alleged sex assaults tell us? What does that tell you as Mr. Nygard's?
Well, it tells us that the issue of similar fact evidence, which is such a significant aspect of cases such as this, can very often dictate an outcome. And certainly the issue of similar fact will be a central feature of whether or not a review will be taken.
Will Mr. Nygard be appealing? Is that something you're looking
at? No, I didn't say that. I said that we will consider the options and consider whether or not the issue of similar fact in this case is such that an appeal is warranted.
What challenges did Mr. Nygard present as a client?
Well, I don't think that...
in the context of the facts of this case, what were the challenges?
I think that the main challenge was the position taken by the Crown that a similar fact was an appropriate issue to advance, and they were successful in the ruling to be able to present similar fact evidence, and similar fact very often dictates the outcome.
Can you tell us what Mr. Nygard is feeling right now?
No, we will be going down to see him right now. Obviously, as you've all observed, he is an 82-year-old man with numerous health challenges, and quite frankly, the period of incarceration has not enhanced his health at all over the last several years, and he has significantly deteriorated in terms of his aging process and in terms of his health since his incarceration.
After he's sentenced here, what happens? Where does he go from here? It's not over as far as the criminal charges. There are other jurisdictions, I understand. So tell us, where does he go from here?
Well, in fact, I don't think it's a straight line. So, and nor is there an easy answer to that. He has an outstanding matter in Montreal. He has an outstanding matter in Winnipeg, and the extradition, the appeal against the order of the minister with respect to his surrender to the United States, the decision has not yet been rendered. It was argued about 6 months ago.
Can you speak generally, not specifically to this case, but as an experienced defense counsel, when a decision is made to put an accused on the stand? Can you generally speak about?
No, it's certainly an individual, case-by-case review and decision. There are more factors. We would be here for the next several hours discussing what goes into that decision. And very often, I will say this, there are very few decisions in a criminal case that ultimately the decision maker is the accused. The lawyer is most frequently the ultimate decision maker, except for 2, and it's always been this way, traditionally and historically, that the 2 decisions which are the client's decisions are guilty or not guilty, and if not guilty, whether the client takes a stand is a client's decision, not ultimately not the lawyer's decision.
And it's not a decision that comes upon easily.
That's correct.
On Friday night, we had a couple of questions. One was about what do we do when we can't reach a unanimous decision on one charge, but we have reached a decision on others. The other was about unlawful confinement.
Right.
Does today's outcome tell you that on those 2 charges that they acquitted him on those 2 charges?
We don't know what the other charge was. So they certainly came to an agreement on the one that was causing them difficulty, and they certainly came to a view that there was not sufficient basis upon which an unlawful confinement could be found beyond a reasonable doubt. So, but we don't know what was troubling them in the first situation.
Can you tell us about your decision to not have the jury witness Mr. Nygard being brought up to the stand in his wheelchair?
I'm sorry?
What was your thinking behind having the jury not see Mr. Nygard approach the stand in his wheelchair?
There are a number of issues, and quite frankly, I don't think that this was wasn't as invisible as perhaps it ought to have been or could have been. But generally speaking, a jury is not supposed to know whether a person is in custody or not in custody. That was why arrangements were made, and quite frankly, I want to compliment the court staff and the police officers involved. They really performed their duties in an exemplary fashion. That was an attempt to try to ensure that the jury would not be aware that he was in custody, so that otherwise it would be a police officer pushing him by wheelchair over and then accompanying him to the stand. And that was an attempt to place him in the witness box prior to the jury coming in order to try to at least make it less obvious that he was in custody.
Brian, do you think if your client had not given that 11-hour police interview that you advised him against giving, that this case would have turned differently?
No, I don't know. I don't. No, it's a difficult question, and one that requires far too much speculation.
Mr. Greenspan, can you just talk in general? I mean, obviously sentencing hasn't occurred, but what can someone receive in terms of a sentence for sexual assault?
I'm not going to get into the sentence right now at all, and it varies significantly, and it varies in accordance with both the severity of the alleged assault, the passage of time. You have to remember that 3 of these 4 convictions took place in the late 1980s. So that's also an issue that has to be considered when you consider the imposition of sentence, and the age and health of an accused is also a variable that you have to consider. So there are too many variables.
Restitution should be considered. Restitution is part of the conditional sentence.
Well,
restitution should be a fundamental thing in the sentence.
I'm not going to answer that. Okay.
From the beginning, the Crown portrayed your client as they had a narrative that he was a powerful person who used that power to manipulate these women. Can you talk about that narrative?
No, if I know that you were present during my closing address, and I certainly very, very clearly addressed that issue in my closing address. I don't think that there was a basis to indicate that there was either luring or that he utilized his position of influence or power to engage in the conduct that he has now been convicted of. Thank you very much. Appreciate it.
Thank you.